Let's continue our discussion about intention to create legal relations in the context of family and social relations. Remembering that we've already discussed the key case of homogeneous, and in some senses what I'm going to cover in this little mini video is the cases that led up to homogeneous and why homogeneous was, as we say in the biz, a big deal. So under the traditional approach, it's presumed that there is no intention to create a legal relationship between a married couple. So in Balfour and Balfour, for example, the courts took the approach that the parties presumed not to intend to enter into their legal relations, into a legal relationship in the contract or in the agreement that they reached. So they saw that in order to establish a contract, there needed to be something more than a mere mutual promise, having regard to the domestic relationship of the parties. In fact, in that case, Justice Aitken uses this rather unusual expression, natural love and affection counts for so little in these cold courts. Somewhat dramatic, don't you think? And really started from the position that it is not, as far as the law is concerned, appropriate or natural for an agreement between two people who are married to each other to end up in a contractual relationship. However, the courts would, from a very early stage, take into account all of the circumstances of the case. So merit and merit is a good example of that, and I think I mentioned it in the earlier video about homogeneous. It's a 1970 English case, and in that case, the couple were in fact separated. They had a somewhat acrimonious relationship, and so the question was whether the husband should be held to promises that he made for consideration to his former wife, or actually probably was still technically his wife, but they were separated. And in that particular case, it was found that the presumption didn't arise, or in fact had been rebutted, because the parties were separated and the circumstances were such to demonstrate that for them to reach any kind of agreement at all, it was likely to be a legal agreement as such. Now, a lot of this is actually the kind of circumstances where these issues arise have disappeared now as a consequence of the 1975 Family Law Act, which makes marital agreements as to property and maintenance binding under certain conditions. And so the legislation has essentially replaced the need for going through this analysis. The intention requirement will easily be satisfied where a transaction between family members is essentially commercial in nature. Since homogeneous, domestic agreements should arguably no longer be regarded as constituting a distinct legal category of their own, although clearly they're often spoken about in this way. Relationships between parties is simply one of the factors to be taken into account in determining whether there is an intention to create a legal relationship. In a non-commercial transaction, the party alleging existence of a contract has the onus of proving that an intention existed, and the existence of that intention to create a legal or a binding relationship will be decided on the facts of each of the case. In commercial transactions between family members, it's going to be quite easy to establish that. Key case here is Rufus and Brewster. So in that case, there was an arrangement between Mr. and Mrs. Brewster and their son-in-law, Mr. Rufus. The arrangement was that Mr. Rufus would take the Brewster's truck from Cooper Pedy to Adelaide on the back of his semi-trailer so the truck could be repaired. And then, as part of the agreement, Rufus was going to engage a driver to drive the truck back to Cooper Pedy, and he could send a load of goods on the truck if he wanted to. The truck was damaged on the return trip, and the Brewsters sought to recover damages from Rufus for the breach of contract, presumably the implied term to look after the truck. Chief Justice Bray held that the agreement created a legal relationship, so there was a contract that could be breached. There was evidence of intermittent hostility between the parties who entered into the agreement in pursuit of their separate commercial interests. Moreover, the whole setting of the arrangement, Bray found, was commercial rather than domestic. So let's look at some other examples. Todd and Nickel is one of my favourite cases, actually. So Mrs. Nickel invited her her niece, well, actually her deceased husband's sister and niece, to move from Scotland to South Australia to keep her company. Nicol promised to alter her will to give them a lifelong possession of her house. And in consideration of that arrangement, the Todds sold all their belongings in Scotland, they resigned their jobs, and they headed over to South Australia to live with Mrs. Nichols. After several years, however, the relationship deteriorated and Mrs. Nichols asked the Todds to leave. So the key question here was there a contract or a binding promise to ensure that the Todds had ongoing access to the house? And in order to demonstrate a contract, you got it. They need to demonstrate that there was an intention that it was a binding promise, a legal relationship. So in that case, the key and critical factors that the court took into account to determine whether the parties intended to be bound despite the fact that they weren't arm's length, that they weren't in a commercial relationship, it was a family relationship, were as follows. They looked at the invitation or the proposal. Was it a promise or an offer? And was it accepted? They looked at reliance, the extent to which things had been done in reliance on the promise. And ultimately they found, yes, there was an intention for that to be a binding promise, that it was expected to continue after Mrs. Nichols' life. And so as a consequence, there was a contract. So what did they do? So the Todds took the following steps in reliance on the promise that was made. They sold their belongings. The niece quit her job in Scotland. They gave up the tenancy of their existing house. They moved to Australia. They did a whole heap of things. Ultimately, the relationship soured and they were told to leave. So in that case, there's no explicit reference to the intention of the parties to create legal obligations. However, the travel by two people to Australia from Scotland was expensive. It wasn't a visit. There was a promise that the house would be available for a long time. Ultimately, it was held by Justice Mayo that there was an intention to enter into a legally binding contract that should be attributed to all of the parties. And as a consequence, a contract existed. Now, as it turned out, in that particular case, the Todds were stopped from exercising their rights under that contract as a consequence of the way that they had treated Mrs. Nichols. But from the point of view of establishing what the arrangement was, we were able to establish, as a consequence of looking at the facts, that there was an intention to enter into a legal relationship. Now, these all seem like old-fashioned cases. Let's move forward now and talk about a more recent example of where this problem can arise. So some of you might remember this case from the news, or maybe you read New Idea, I'm not sure. But this is the case of Ashton and Pratt, and whilst it sort of seems a little salacious or saucy in some ways, I've chosen to add it as an example because I think it shows really clearly what the state of the law is when agreements are made in a social and domestic context, and demonstrates that contracts will not be enforceable unless the parties can demonstrate, or the parties seeking to demonstrate the existence of a contract meets the onus of proof and demonstrates that an intention to enter a legal relationship exists. So this is a New South Wales Supreme Court decision. There have been subsequent decisions in this matter more recently, but ultimately the case that I have cited there on the slide, and there'll be a link to it in the materials, really does a good job of summarising the state of the law in relation to promises made in the context of family, social or domestic arrangements. And Justice Brereton's judgment is the one that I am pointing you to. So what are the facts here? Ms. Madison Ashton, the appellant, provided the late Mr. Richard Pratt with escort services over a period between 2003 and 2004. In November 2003, Mr. Pratt asked Ms. Ashton to take up the position as his permanent mistress and not to return to the escort industry. He stated that he would pay her some allowances, he would give her a car, and he would set up a trust fund for $2.5 million for each of her children. When I say that this is what he said, this is what was allegedly said according to the evidence given in court. In February 2005, Ms. Ashton received an email from Mr. Pratt's associate, a gentleman called Sean Bowman, who it turned out had also been in a relationship with her at some point of time, offering her $100,000 and the transfer of a car in full satisfaction of all claims that she might have against him. On that day, she was transferred some money and the ownership of the car. In November 2005, she signed a document that Mr. Bowman presented to her acknowledging the receipt of $50,000 in full settlement of all claims against Mr. Pratt. So by this time, the relationship had soured. Ms. Ashton actually denied receiving any money, and she sued Mr. Pratt's executor, the first respondent, claiming that the November conversations constituted a binding contract that the first respondent, the estate, in other words, was stopped from denying that a contractual relationship had been entered into. The primary judge found that while the terms of the November conversations were sufficiently certain, they weren't intended to create a legal relationship. Any contract, if made, was void against public policy because it was essentially a contract for sexual services. Sorry, I've just got to find my notes here. So he found that the first respondent was not stopped from denying that the conversations were legally binding due to the lack of detrimental reliance, and any binding obligations had been released by the transfer of the money in the car in either February or November 2005. Subsequently, Mrs. Ashton's children, who were the second and third respondents, joined in the proceedings seeking to enforce the term in the conversations to create the trust, the $2.5 million trust. The relevant issues on appeal were firstly, whether the November conversations gave rise to a binding contract between Ms. Ashton and Mr. Pratt. Secondly, whether the first respondent, the estate, was stopped from denying that the conversations were binding. And third, where the correspondence entered into in February 2005 constituted some kind of accord and satisfaction between the parties, and whether the actions in November 2005 involved any unconscionable conduct. So what we're interested in here particularly is whether the November conversations, as they're called, created a contract because they demonstrated intention to enter into a legal relationship. So, Justice Brereton said that there were two factors that suggested that the parties didn't intend to create a legal relationship. Despite substantial payments being promised, neither party sought legal advice nor recorded the agreement in writing. Straight from the judgment, he said, ordinary people in their position would not have intended that in the event that either did not fulfill their respective promises, the other could enforce the promise in a court. There is considerable force in the defendant's submission that it would not have been envisaged that, if Miss Ashton returned to the escort industry, Mr. Pratt could obtain an injunction to restrain her, nor that if she did not fully perform the role of mistress, he could claim damages for disappointment. While these factors aren't decisive in all cases, Brereton held that Ms. Ashton could not overcome these matters to argue that there was an intention to create legal relations. The court also held that the contract itself was sexually immoral and or prejudicial to the status of marriage, and historically contracts for an immoral purpose are also unenforceable. So this is a really good example of the use of the objective test. I must admit the moral overtone makes me somewhat uncomfortable. I personally don't think that's the role of the court to make that judgment, but let's see what you think. So on appeal in 2015, the full court dismissed the appeal. In relation to the issue of whether a binding contract had been formed, they found the fact that a contract constitutes a family arrangement does not raise any presumption regarding the party's intention to enter into a contract. Rather, this forms part of the surrounding circumstances from which it will be determined whether the contract was formed. So essentially relying on homogeneous here. But they found that the parties didn't intend to create a legal relationship, and if they did, any contract that they would have formed would have been void for uncertainty. Um, Regard was had to the nature of the arrangement, the lack of any language of obligation, and the failure to delineate important terms such as what Mrs. Ashton's obligations as mistress were, how long the agreement was going to continue for, and the terms of the trust for the children. So we'll talk a little bit more about certainty as we go forward, but these were key issues. It was also inherently improbable that Mr. Pratt would have bound himself to make significant payments in return for a promise that was essentially unenforceable. So in the next video, I'm going to move on to intention in government contracts. Thanks for listening so far.